joining us. My name is Katie Perez, and I'm a senior associate here at Scott Legal PC. So today we're going to spend some time talking about the extraordinary ability visas and green cards. And so just a few things before we get started. Some of you may know that our firm was founded on an E2 visa several years ago. Our founder, Ian Scott, is in the U.S. on an E2 visa and has been on several different visas, including the F1, a TN, the B, and the H1B. Scott Legal PC is a full-service immigration law firm, and we offer immigration services in several different areas, including the E2, the E1, TN, L1, family immigration, national interest waivers, EB-5s, extraordinary ability visas, and more. So we will continue this webinar series, doing at least 2 webinars a week on different topics. At the end of this webinar, we will send out several useful tools. We will send you a copy of the PowerPoint presentation from today. We'll send you a link where you can download guides that go through the visas options in more details. We'll also send you a link where you can sign up for additional webinars. This webinar will be recorded and it will be available on YouTube. We'll also send you a link for that. We do encourage you to subscribe and hit the notification button as we regularly upload immigration videos on a wide variety of topics. We will also send you a link where you can arrange for a consultation with one of our experienced immigration attorneys if you would like to discuss your case in more detail. If you do have any questions throughout the presentation, please put them in the chat box and we will try to address them at the end of the presentation. So today I will be presenting the first half of the webinar. We are also joined by another senior associate here from Scott Legal PC. Her name is Jiyae Hwang. Jiyae earned her undergraduate degree from Harvard University and her law degree from New York University. So she is an amazing resource, and she's advised many professionals on the EB-2 National Interest Waivers, EB-1s, O-1s, and other green card matters. Okay, so let us get started here. So we will begin with just discussing the extraordinary ability visas. So the first ones we have listed here are the O-1A, which is a temporary non-immigrant visa for individuals with extraordinary ability in the sciences, education, business, or athletics. For this category, it does have a very high standard in which you have to be one of a very small percentage who's risen to the top of your field in your profession. We also have the O-1B. This is another temporary non-immigrant visa for people with extraordinary ability in the arts. So O-1Bs are treated a little bit differently than the O-1A. The standard for the O-1B for arts is slightly lower. The person must have received distinction, meaning a high level of achievement evidenced by a degree of skill and recognition substantially above that ordinarily encountered. Within the O-1B visa, there is also a subcategory for people with extraordinary ability visa in the motion picture and television industry. The standard for the motion picture and television industry is a little bit higher, so you do have to show that you have a record of extraordinary achievement in the motion picture television industry, such that you have a very high level of accomplishment evidenced by a degree of skill and recognition significantly above that ordinarily encountered, to the extent that you are a person that is recognized as outstanding, notable, and leading in your field. So this one, it would be in relation to your peers in the industry. So again, the O-1A and the O-1B are both temporary non-immigrant visas. With these visas, you will have the ability to work in the U.S., but you do intend to come here temporarily to fulfill that work. In contrast, a green card option would be for someone who's intending to come to the U.S. to remain here permanently. So we will talk a little bit about the green card options for people with the extraordinary ability as well. So first we have the EB-1A. This is very similar to the requirements of what the O-1A and the O-1B look like, but there's not the separate category for the arts. So this category is for those with the extraordinary ability in the sciences, arts, education, business, or athletics, and is all under one umbrella of the EB-1A. So the individual for this must be one of a very small percentage who has risen to the top of their field of endeavor, and that you've sustained this national international claim and your achievements have been recognized in your field of expertise. Importantly, you must be coming to the U.S. to continue to work in that area of extraordinary ability. So if you're someone who has had this prominent career and you want to retire and you think coming to the U.S. would be a great idea, if you're trying to apply with this EB-1A, that wouldn't really work for you because the government would want to see a statement of proposed intent of what you plan to do in the U.S., and it does need to be related to your area of extraordinary ability. So we also have the EB-2 National Interest Waiver Green Card. This one's not always lumped in with the extraordinary ability visas, but it could be a very good option for people who have been on maybe the O-1B and they don't quite meet that EB-1A standard yet, but you still do have this very impressive background and you're working on an endeavor in the U.S. that does have this substantial merit and national importance. So you could be eligible for that EB-2 second preference visa if you are a member of the professions holding an advanced degree or its equivalent, or you have this bachelor's degree and 5 years progressive work experience, or you are a person with exceptional ability. So those are the threshold requirements. If you are claiming that exceptional ability, you need to be able to explain how your area of exceptional ability directly relates to your proposed endeavor. The term endeavor is more specific than just like a general occupation, so you should be able to offer details to the government, not only to what the occupation normally does, but what type of work you're proposing to undertake specifically within that occupation. So, for example, if you're going to be working as an engineer, then you would really want to explain your proposed endeavor um, in a lot of detail and explain the specific projects and the goals that you will be working on as an engineer. You would need to provide a detailed description just explaining that proposed endeavor, provide the supporting documentation to establish that your endeavor is of national importance and does have that substantial merit as well. You would also need to show that you as a person are well positioned to advance this particular endeavor. So there needs to be kind of a nexus. You always need to think how everything kind of connects within your case. So then based on that, you would argue to the US government that, they should waive that normal labor certification process that normally requires the US employer in a labor market test, and that you shouldn't have to go through that because the work you're doing is so important that it's beneficial to have you here in the US. So one very important thing about the EB-1A and the EB-2 National Interest Waiver is that you can self-petition. These are more flexible in some ways than what you would get with the O-1A or the O-1B. So with the O-1A or the O-1B, for those temporary visas, you will need to have either a U.S. employer, a U.S. agent, or an agent operating as a foreign employer. Okay. So we'll discuss a little bit the specific requirements for in more detail now. So for the O-1A, you can demonstrate that you have received a really significant, a major internationally recognized award, something like the Nobel Peace Prize or Pulitzer, something of the high prestige, high caliber award. However, most people don't have those, so much more commonly people are going to qualify on the basis of showing that they meet at least 3 out of the following criteria. So 3 is the minimum, but if you have more, you would want to provide evidence that you meet those criteria as well. So first is the receipt of a nationally or internationally recognized prize or award. So for this, you would really want to consider, is it the type of prize? Is it national, the whole nation? Is it international, offered to more than one country? Um, a prize is really something offered or striven for in competitions or contests. An award is something conferred or bestowed upon, especially based on your merit. So you would want to consider like the criteria for winning the prize, who are the past honorees, the number of prizes given each year, are there limitations on the competitors, things like that. So you would do want to think about like, was this an award you won as a student? Was it something given to you by your college or university? If so, that might not be super compelling depending on the circumstances of the awards, because it is always important to think about your petition holistically. So the type of evidence you're submitting for each criteria, is it really raising the profile of your petition or is it bringing it down? So, if you're providing something a prize or an award you won from your university, but it isn't really that prestigious, it might not be that beneficial to provide it as supporting evidence for your petition. In contrast, if the award is a very prestigious award, even if you did win it at your university, but maybe, this is a very competitive prize, there's other people that compete outside your university, there's very prestigious other competitors, then maybe it does raise your profile and you would want to provide that evidence in your case. The next one would be memberships and associations in your field, which require outstanding achievements. So here you would want to provide evidence like the membership actually requires you to have some outstanding achievement in order to be invited to be a part of that group. It is important to look at what are the requirements for entry. So can anybody enter, or does it actually require those outstanding achievements? Factors that might suggest the membership is not based on outstanding achievements might include, does the membership require a fee to join? Does it just require a level of education, something like that? So as an example, an attorney who has just paid the fee to join the bar, that would not count as for this one, the membership and associations that require outstanding achievements, because it is really just based on, your fee, you took the bar and you passed it. Okay, next we have published materials in professional or major trade publications or major media about you and about your work or something that you are working on. So for this requirement, you should consider the evidence that you're providing should be about you. The publication can cover a broader topic and include a substantial discussion about your work, or it mentions you in connection to the work, but here the government will really focus heavily on whether or not this article was about you. So next we have original scientific, scholarly, or business-related contributions of major significance in the field. For this one, you would want to consider things like patents, processes, things that are original that you can demonstrate, maybe you developed. It is important for this criteria for you to really think about, has the work already impacted the field? So if you're providing evidence that you've created something and it has a great potential impact, that wouldn't be sufficient. So oftentimes, people provide testimonials in support of this requirement. The testimonials will, go on about the potential impact this person may have or what they created may have in the field, but that potential impact is not sufficient. You really do need to show how your work has already been a major impact, has majorly impacted the field already. So next we have authorship of scholarly articles in professional journals or major media in the field. So this can include publications in professionally relevant journals or published conference presentations at nationally and internationally recognized conferences. This one, generally people are in the academic field who provide evidence related to this criteria, but it could apply to other fields as well. Next, we do have a high salary or other remuneration for services as evidenced by contracts or other reliable evidence. So again, here you're going to be looking at what is your area of expertise, your area of extraordinary ability, what is your occupation, and you'll also be looking at where you are working. So are you earning a high salary in relation to others in that same field as you? So you can show this by providing a comparison of your salary to labor statistics. That's often what people provide as evidence. I often just say, make sure you compare the apples to apples. So if you're going to say, give evidence of your hourly wage, then you'd want to compare it to an hourly wage on that the labor statistics, not the annual wage. We also have participation on a panel or individually as a judge of the work of others. So here you must show that you've participated as a judge of the work of others in your same or allied field. As an example, this could include reviewing abstracts or papers submitted for presentation at scholarly conferences or serving as a peer reviewer for scholarly publications. You might want to document like the work you did review by submitting a copy of the request from the journal, accompanied by evidence that you did actually complete that review. We also have employment in a critical or essential capacity for organizations with a distinguished reputation. So here you would really want to focus on your role within the organization. So you do need to provide detail of what you did for that organization. Not just the title, but explain your duties, maybe provide the organizational structure so that you can really convey to the officer of the government, you know, um, where you were within this organization and explain how your role was important or critical to this organization. To demonstrate that it's critical, you may want to explain how you contributed in some way that is of significant importance to the organization or the establishment's activities, to show that it was essential. Um, Generally, a leadership role in an organization would qualify as critical or essential. The other part of this criteria, you do need to show that the organization was distinguished. So there's kind of two prongs within this criteria. So if you were a CEO of a very small company, you might have difficulty showing that this specific company was very prestigious or it does have this distinguished reputation. Conversely, if you worked for a large organization like Apple or Amazon, but you are just working in the factory, with hundreds and hundreds of other workers doing the same exact job, you would probably have difficulty showing that your role was critical or essential. But of course, it's pretty easy to show those types of companies do have a distinguished reputation. So you do have to think about the prong holistically. Okay. Okay, so we'll discuss now just the O-1B requirements. So again, the O-1B is for people in the arts and those in the motion picture television industry. The O-1B does have a very similar structure to the O-1A in the sense that you're going to try to qualify by either providing evidence that you have this significant national and internationally recognized award, like a Grammy, or satisfying at least 3 out of the following criteria that we'll discuss now. So the first one is having been and will perform as a lead or starring participant in a production or event with a distinguished reputation. So here you would want to provide evidence that that you had maybe a prominent role within an event or a production. Usually to be a lead or starring role, you would want to show that you maybe had a principal role, one of the main roles. A starring role means a role of great prominence relative to others in the production. Generally with this criteria, I think the difficulty is showing the future element. So you do kind of have two parts to this criteria as well, that you've already performed as a leader starring participant in the past, but also that you will perform as a leader starting participant in the future. So sometimes showing that future element can be difficult because you may not have those critical reviews or advertisements for the event or production yet. So we also have critical reviews of other published material in professional and major media by or about the beneficiary. So here, I think the difficulty for people can be to show that the media is major. So the government doesn't hold much weight for articles that you can self-publish or are not vetted versus articles in larger newspapers like the LA Times or New York Times. So you do need to show within that evidence that the beneficiary, the applicant, has been recognized for achievements that are nationally or internationally recognized. Okay, so we also have the other criteria listed here is that you can provide evidence that the beneficiary has performed and will perform as a lead or starring or critical role for organizations or establishments with a distinguished reputation. So here, it is important to remember that um, this criteria is different from the very first one that I discussed for the O-1Bs. A lot of times people conflate them or they just assume, I performed as a critical role in a production or event, so now I also satisfy this one, but they are separate and the government does look at them separately. So this one would really be that you're serving in a critical role for an organization versus just an event or production. So you might want to think of it as, if you're serving as a critical role for an organization, maybe you're serving as the CEO. Generally the role is more permanent versus if you're an actor, um, in a production that's more of a temporary role. That's not to say you can't explain that they cross over, or, someone who's a very well-known, prominent actor. So if you're Tom Cruise and you're serving in a production or role, you might be able to argue that your role is so important that, it could also be a critical role for the organization as well. But you would just really need to look at them individually and be able to explain that to the government, which can sometimes be difficult for people. So I would say just really look at what is your role for the organization versus was it just a production or event. Okay. So you can also provide evidence of major commercial or critically acclaimed successes in the performing arts. This is evidenced by box office receipts or record, cassette, compact disc, or video sales. This criterion does have outdated evidence requirements on it, so most people don't have cassette or record sales anymore. So for this one, you might want to be think outside the box a little bit, be a little bit more creative. Um, really consider your field. What are you doing in your field? Can you show that you have some commercial success in a different way? So maybe you have a YouTube channel and you have been very successful on that YouTube channel. Maybe you can show how much money you've earned from that channel, and that could translate into, the commercial success. If you're demonstrating the critically acclaimed success, the evidence should demonstrate that you have received that public-facing praise or positive reviews in your relevant field, such as from professional art, television, or film critics. Okay, so this one you can also provide evidence that you have received that high salary as well, just like for the O-1. So you can, again, do this by providing evidence of your salary and compare it to the labor statistics. But again, just make sure you're comparing those apples to apples. If you're providing that hourly wage, again, you want to compare it to an hourly wage in that labor statistics. I think I skipped one really quick. Another one you can provide is evidence of significant recognition for your achievements from organizations, government agencies, or other recognized experts in your field. This can be just a testimonial. So for this one, I always tell people, you really do need to make sure that the testimonial is focused on your achievements. It doesn't need to focus on your good human qualities. A lot of times people will write, this person was a great person. They have the potential to make a great impact. They're a hard worker, that sort of thing. So that would not be sufficient. You do want to convey to the officer, to the government, that this person does have achievements. Achievements can be viewed, I think, or explained very, very widely. I mean, but it would just be your job to show that whatever you're explaining in that testimonial is an achievement to the government. Okay, lastly, for the O-1Bs, you can also do what is called comparable evidence. So if you can explain to the government that the other criteria don't apply to you, maybe you have this very niche field, then you can try to explain why they don't apply to you and then provide evidence that is comparable to the criteria we just went over. So this, I would say, is kind of a big hurdle to meet, but it is something you can consider if you do, again, have that very niche field that's not common. And then just to note that the comparable evidence is not available for those in the motion picture television industry. Okay, so we'll just go over quickly just generally the comparison between the two O-1 and the O-1. So again, the O-1 is for people in the sciences, education, business, or athletics. The O-1 is for those in the arts and motion picture television industry. The standard for the O-1 is one of a small percentage who has risen to the top of their field of endeavor. The arts is a little bit lower. So again, it is a high level of achievement as evidenced by a degree of skill and recognition substantially above that ordinarily encountered. For those in the motion picture television industry, this would be a level of claim substantially above that of their peers. Again, so you're comparing the person to the peers. So for each visa, you can be issued 3 years, and then you can extend generally in increments of 1 to 3 years, depending on your work. So if you do have that first initial visa for 3 years and your work has concluded, and you're able to show the government that you do have new work with new contracts and that work will cover the span of another 3 years, you could be approved for 3 years. However, if you are just continuing the same work, the same field, the same project, then you could be approved for a 1 year extension. So under the O-1A and the O-1B, you can also have your family join you. This could include your spouse and children under 21 years of age. So your kids are permitted to attend school in the U.S., but unfortunately your spouse would not get that work authorization with their own. So if your spouse does need to work here in the U.S., they would need to look for a different visa category that they could qualify for. And then, sorry, just one more thing about the O-1A and the O-1B. If you do have a field that you work in, a job that you work in, and you can maybe be considered for the O-1B versus the O-1A, you may want to do that just because the O-1A is just a bit of a higher standard, so you may be better off applying for that O-1B if you can show, that you fit within that visa category. Okay, so we'll discuss a little bit about the requirements for the EB-1A. So for the EB-1A, this is very similar to the O-1A and the O-1B, but the language is a little bit different because it does incorporate everything together. So under that one umbrella, again, you have the arts, sciences, education, business, and athletics. But the structure is very similar where you can qualify with a major award. However, most people will qualify based on showing that they meet at least 3 out of the 10 criteria listed here in the regulations. And they are very similar to what we just previously described in the other 2 slides, but I'll read through them quickly for everyone. So if you're trying to apply for the EB-1A, you can provide evidence to the government that you have receipt of a lesser nationally or internationally recognized prize or award for excellence, evidence that you do have that membership in an association in the field which demand outstanding achievement for their members, evidence that you have published material about you in professional or major trade publications or other major media, evidence that you have been asked to judge the work of others, either individually or on a panel, evidence that you do have some original scientific, scholarly, or artistic, athletic, or business-related contribution of major significance to the field, evidence that you do have authorship of scholarly articles in professional or major trade publications or other major media, evidence that your work has been displayed at artistic exhibitions or showcases. You could also provide evidence that you have performed as a leader, critical role in a distinguished organization. Evidence that you have commanded a high salary, high remuneration for your services as compared to others in the field. And then you can also provide evidence of your commercial success in the performing arts. Okay, so now we will switch over to Jiyae, our other senior associate, and she's going to discuss just the EB-1A green card requirements a little bit more.
Yeah, thank you, Katie, for the informative presentation. And let's now look into a little bit more detail on what are the requirements to qualify for the green card under the EB-1A classification. So as we just went through in the previous slide, the requirements are phrased in a very similar language with the O-1A requirements. Either, you would show that you've received a major internationally recognized award, such as, a Nobel Prize or, Grammy, Emmy, or Tonys or something like that. Or in the vast majority of cases that we would see, you would show that you meet 3 out of the 10 criteria that is listed in the regulations. Now, let's talk a little bit about the Kazarian analysis, which is an approach that USCIS has been using so far until very recently, which has a 2-step analysis. Now, we'll talk a little bit more about what happened in 2026, but let's just go through the Kazarian analysis and see how that works. So under the Kazarian analysis, the government would look at an EB-1A case in 2 steps. So in the first step, the government will look at the evidence and see if you meet the plain language of at least 3 out of the 10 evidentiary criteria. And I'm assuming that, uh, for the vast majority of cases, you would be falling into that bucket of cases where you would, present at least 3 out of the 10. So, for example, have you written any scholarly article in your field that has been published? Have you been featured in any, major media? Have you received any award that is nationally or internationally recognized? Have you made any original contribution in your field? And if you can show that you meet the very plain language of each criteria, then the government would kind of, do what is like a checkbox and say, okay, well, you've provided evidence meeting this criteria. However, under this Khazarian framework, the government wouldn't stop there. So even if you've provided enough evidence meeting at least 3 out of the 10 evidentiary criteria, the government would do another second step analysis, looking at all of the evidence in totality, and sometimes would deny based on the second step analysis, which was asking that whether the quality of the evidence in totality, tended to paint a picture of a person who has really reached the very, very top of their field. Did the quality of the evidence in totality, when you look at all of what has been submitted, does it paint a persuasive picture of someone who has reached the very small percentage of people who have risen to the very top of this field of expertise? And by nature, you can see that it's a little bit of a subjective analysis that is, that comes into play in this second step analysis. It's really phrased in a way that some subjectivity could enter the analysis. Now, what happened was that in January 2026, a federal district court in Nebraska ruled that actually USCIS's adoption of this Khazarian two-step test was actually unlawful, and actually reversed the denial which was only based on the final merits determination test. So in that particular case, Mukherjee versus Miller, the petitioner had met the first step, which is shown evidence meeting the plain language of at least 3 out of the 10 criteria. But on the second step Khazarian test, this person was denied. And what the district court said was USCIS's adoption of this two-step test was actually something that was not contemplated in the original, when Congress passed, the law for this particular classification. So actually, USCIS should not be using this test to deny petitions that otherwise meet the plain language of the criterion. So while the decision is not binding across the country, the reasoning does serve as persuasive authority for other courts and could result in policy changes at USCIS. And another update that happened very recently is that USCIS actually, the government actually dropped their appeal of Mukherjee versus Miller, which is another positive indication that maybe the government agrees with what the reasoning of the district court, and perhaps they may, be announcing some policy changes on, whether they would continue to apply the Khazarian test. So definitely some indications of possible change coming forward with this new litigation that has happened. All right, so now let's move on to the next slide. Okay, now let's shift gears a little bit and talk about the EB-2 NIW, which is another green card classification, which is a little different from the O-1A and the EB-1A in terms of the extraordinary ability considerations and the factors, but nevertheless, there can be significant overlap with, the facts and circumstances of the types of clients who may be exploring extraordinary ability green cards, or who may not be easily meeting the EB-1A classification, or those who may be a little bit more junior in their careers, but nevertheless, if their projects have have the expectations of a large impact in the industry, or if their projects have, ties to the government, or otherwise can show that this will have a broader impact to government priorities. The EB-2 NIW could be an alternative green card option one can consider. Um, and the other aspect of the EB-2 NIW is that it is one of the few categories of green cards that can be self-petitioned, where you don't need a U.S. job offer, you don't need a sponsor to drive forward your employment-based green card petition. But if you can show that um, the facts of your case meet all of the eligibility criteria of the EB-2 NIW, you can self-petition as a foreign national. So that can be a significant advantage for certain people. So the EB-2 NIW is definitely a very popular option that a lot of our clients consider. So let's dive into the requirements. So the first element to consider is that, do you meet the threshold requirement, EB-2 threshold requirement, that is necessary to even start considering the NIW. So in order to meet the threshold requirements for the EB-2 category, you should either have an advanced degree, which is defined as a master's degree or higher. So, for example, a PhD degree definitely qualifies, or even degrees like an MD, a medical doctor, or a JD, Juris Doctor. Those types of degrees also are classified as advanced degrees because you typically need to already have a bachelor's degree in order to get admission to those types of programs. So a JD, MD would be classified as an advanced degree. One thing to note is it is very important to get a U.S. education equivalency certification if your degree was not from the United States. So if you get a degree from Australia, Canada, the UK, wherever, you would want to get that U.S. degree equivalency report from, one of the agencies that cite to what is called an AAC-RAO database, to make sure that the USCIS understands that this actually does qualify as a master's degree in the US standard. Or if you're qualifying with a bachelor's degree plus 5 years of post-baccalaureate experience, if you're using the underlying degree as a foreign degree, then you definitely want to present the U.S. education equivalency report to make sure that the government understands that this is, although it's a foreign degree, it is the same level with a bachelor's degree in United States standards. And sometimes there is a mismatch, which is quite a bit of a risk factor. If you get, a mismatch there, then you may simply not be eligible for or under the advanced degree professional channel, and you may need to argue, exceptional ability instead. So definitely this is a very important strategic factor to check before you're exploring the EB-2 NIW option. When I speak of bachelor's degree plus 5 years of post-baccalaureate progressive work experience in the profession, for the NIW, the experience must relate to the degree, and the degree must also relate to the proposed endeavor. And assuming that, you do need to prove with evidence how your work experience has increased in complexity and your responsibilities have increased in seniority over time. This upwards progression, is very important when you're trying to prove the 5 years of post-baccalaureate progressive work experience. Really, the best way to prove this is by getting employment confirmation letters from your previous employers on company letterhead. And also you need to make sure that substantial detail is added in those letters that not only say that your duties have changed, but show how your duties have changed with enough detail to make it persuasive to USCIS. Now, if you don't have a master's degree, if you don't have a bachelor's degree, you can still consider meeting the EB-2 threshold by showing that you have exceptional ability in the sciences, arts, or business. And one thing to note is exceptional ability is a very different concept than extraordinary ability. It is really a much lower standard. The government is only looking for someone who is at a level that is significantly above what is ordinarily encountered in the field, which is definitely different from the extraordinary ability threshold, which looks for someone who is at the small percentage who has reached the very, very top of the field. So how do you prove to the government that you have exceptional ability in the sciences, arts, or business? Definitely, you need to present at least 3 out of the 7 evidence shared criteria that is listed here. So, for example, any degree that you've had in the field, licenses to practice your profession, membership in any professional association that's relevant to your field, and if you can show that you have received recognition for your achievements and significant contributions to your field by your peers, government entities, professional or business organizations. A variety of evidences could be used to show evidence under this prong. So if you can show at least 3 out of the 7, and if the totality of the evidence submitted tends to show that you're someone who is operating at a level that is significantly above what is ordinarily encountered, then it is likely that you would meet the EB-2 threshold through by showing exceptional ability in your field. Right, so now that you've met the EB-2 threshold, the other challenge for supporting a national interest waiver petition is providing enough evidence that demonstrate you qualify for a national interest waiver. And I would say that is probably the harder challenge of the two. So the first prong is that an applicant must prove that their proposed endeavor in the United States has both substantial merit and national importance. And what does that really mean? The key thing to keep in mind for a proposed endeavor is that it must be more specific than simply proposing to work in your field. So if you're an engineer and if your proposed endeavor is just to continue working as an engineer, unfortunately, the government is not going to find that sufficient as a proposed engineer. What the government is looking for is what you're planning to do within that field. So let's say you are an engineer and you are researching a different way of manufacturing silicon chips that will make it, easier to stack more data into the same area. So let's say you're working on some kind of, very cutting edge R&D technology. And let's say you have people who are interested in your research. Let's say you're somebody who has published similar research regarding this technology in the past, either by, presenting at conferences or, if you've developed technology that's been patented, for example, if you can show copies of your patents, if you can show a track record of those impactful previous researches, then maybe the government will look at your research plan and say, well, this research plan definitely seems to have the potential to advance the envelope of the field as a whole. It really seems like this technology is cutting edge, and it will advance technology for the field more broadly instead of simply, benefiting the bottom line of one particular company because it is an innovation in the field. So when you are thinking of the proposed endeavor, definitely specificity is very important. You need to convince the government of why your particular project doesn't just benefit your immediate clients or immediate employer, but results in broader benefits to society, technology, to the field as a whole. So you can consider getting expert letters from independent experts who can talk about the challenge that your field is facing and tie it in with your particular project and how your project will advance the field. So that's one strategy you can use. If you have government pronouncements and declarations, you can link that with your proposal and talk about how your proposal can significantly advance these government priorities. But keep in mind that government reports just talking about the importance of a particular field will usually not be enough to support national importance. And that is definitely a strategy that may have worked in the past but does not work currently in the current adjudicatory environment. Really, in recent years, the government has been looking for very, very specific and targeted evidence of why your particular project is important for the field, not evidence that why the field is important for the US as a whole. So really, the adjudicatory standards for NIW have shifted a lot. So definitely keep that in mind when you're thinking about how to frame your proposed endeavor. Other data showing importance. Really, the important thing is to have enough backup of that tends to demonstrate the impact, the prospective impact of your project that is ongoing, your proposed project for the future, and make sure that those plans are substantially corroborated. That would be the challenge for NIW cases going forward. The second prong is to show that the individual yourself is well positioned to advance the proposed endeavor. And here, the focus is on the individual, not the project that is being proposed. So the government will look at factors such as the person's education, experience, a track record of success in similar projects as the proposed endeavor, any intellectual property that you have published that's related to the proposed endeavor, which shows that you have a track record of having already influenced the field through your innovations. Those types of data can be very helpful for the second prong. Any advancement towards the endeavor. So if you are already in the United States, and let's say you're an entrepreneur who's, developing this innovative business idea, that's developing this new technology and wanting to commercialize it. And let's say you're already in the US on an E2 visa, for example, and you've already made progress on this business plan. That can be very helpful in showing that you're well positioned to advance this endeavor if you can show how your business has been growing since the since the founding of your business. You can be on an F1 visa and be on a STEM OPT. Maybe you're developing your business on a STEM OPT status. So really, if you can show that you've already made progress in your endeavor, and let's say U.S. entities have already expressed their interest in your project by, maybe, signing contracts for pilot projects with your business, or maybe your business won, some grants from venture capital or those types of startup competitions, or maybe your project has won, admission to a prestigious incubator or accelerator like Y Combinator, Techstars, or something like that. Those types of evidence of interest from relevant U.S. industry and government entities can be very helpful towards meeting the well-positioned prong. So the more public-facing evidence you have of the impact that your idea has been making in the field up to date, the better your case will be for the NIW. And finally, for the third prong, there must be a showing that on balance, it will be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. And here we're looking at sort of a balancing test. So we want to make sure that, if we think about the first prong, some of the evidence that we collected would speak to the systemic and broad benefits that your work can have on the field by improving manufacturing processes, for example, improving medical practices if you're somebody who's in medical research, for example. Those types of broad systemic benefits can impact millions of people, which you can use to support the third prong balancing test by showing that the government will benefit more from your impactful project than the average, than the average interest of protecting the one job spot for one U.S. worker. Similarly, if you are an entrepreneur and if you have a business that is already creating a high number of U.S. jobs, you can perhaps point to that and say, you're actually creating more jobs and creating a high number of jobs by your entrepreneurial activity, which can, already advance what Congress intended when the Congress instituted the labor certification program. So that fact can also be used in your favor. Similarly, if you can show that you have experience and knowledges that cannot easily be replaced by another U.S. worker with minimum credentials, such as, the education experience and track record of success that you can show for your second prong. You can reuse that evidence and argue to the government that it will be difficult to replace your specific and unique knowledge. Which is essential for, this project of national importance. And that can also be a basis you can use to argue the balancing test. So in conclusion, make sure that you have enough evidence to meet all three prongs of the matter of Danaher test. All three prongs must be met, even if you're well positioned and even if on balance, your case is favorable. If you cannot prove that your proposed endeavor has national importance, unfortunately, the NIW claim would fail. So ensure that you have enough evidence for all three prongs of this test. All right, so we'll move on to the next slide. So let's talk a little bit about expert opinion letters, which are a very important part of all of the visa categories that we've been speaking about today, EB-1A, O-1, and NIW. So what is included in expert opinion letters? For these types of petitions, it may be good to obtain expert letters from key individuals in the industry. And really, the purpose of including those expert letters would differ based on what you're trying to prove. So let's say we're working on an NIW case. For an NIW case, perhaps you want to get letters from independent experts in the industry who can talk about your proposed endeavor and what is the expected impact of your proposed endeavor to the field. And that way, you can support a claim for national importance. And if you can get a letter from a relevant government agency representative, so if you're working in on an environmental related project, and if you get a letter from someone who's working at the EPA, for example, that would be certainly very relevant to an NIW claim. So those types of letters can help the first prong. Now, other types of letters for the NIW may be helpful for the second prong. So if you're trying to describe how your work has influenced the field in the past, then you would get letters from people who have worked with you in the past, who is familiar with your work, and who can talk about what the limitations of the field were and how your work actually, broadly impacted the field and improved the best practices of the field. Similarly, for O1 cases or EB-1A cases, you would likely want to get expert letters talking about your past achievements. So those letters would focus on your achievements in the past, how you have impacted the field, how your particular achievement sets you apart from the vast majority of people who are working in the field. You want to give more concrete detail that would show the USCIS why your skills are unique, rather than rather than just conclusory statements. So one thing to really note with expert letters is USCIS won't rely on conclusory statements, which are just repetitions of the regulatory criteria. So for example, if you're trying to use an expert letter to prove that you've made a critical role for an organization, if the letter just says that you've played a critical role and stops there, this person played a critical role. USCIS would not rely on that because that is simply a conclusory statement. Anyone can make that statement. But if the letter goes into a lot more detail and talk about why your role was important for the organization. So for example, there is narrative about, what your role was for the organization and what are the things that you actually did, what was the problems or the limitations that the organization was facing, and what innovative approach did you institute to really solve that problem for the organization or really advance a key priority for the organization? What kind of priority was advanced? So those types of concrete detail is very important to really make these expert letters play the role that we want them to play and support a strong case for these extraordinary ability or NIW petition. One other thing you do want to make sure that you clarify the background information of who is writing the letter. So usually what we do is include a full-length curriculum vitae, resume of the letter writer, with the letter that is being submitted. You want to make sure that these people are, kind of a senior stature in the industry. You don't want to get letters from people who are more junior than you, because that will be less persuasive in terms of how they can represent the standards of the field. So you do want to make sure to talk with your lawyer who's going to provide the letter. Strategically, some adjustments may be helpful. How does the individual know you? It is very important to have both inner circle letters and independent expert letters, and you can use them for different purposes. Inner circle letters from people who've directly worked with you can be helpful if you're trying to provide narrative detail about your achievements in the past with respect to a particular organization or project. Independent letters could be very helpful if you're providing to USCIS an assessment of your influence in the field, because somebody who's active in the field but haven't worked with you, but nevertheless know you for your achievements, can provide that objective assessment of the significance of what you've done. So both types of letters can be useful and could serve different strategies for your case. All right, so we'll move on to the next slide now. So let's talk a little bit about some other strategies that come into play when you're trying to choose which category you should apply for. The first question to ask is, do you want to stay in the United States temporarily or permanently? And as Katie mentioned before, the O-1 visa category are non-immigrant temporary visas, well suited for if your purpose in working in the United States is temporary. Keep in mind, though, that it is possible to continue to renew and extend your O-1 visa as long as there is continued work opportunity for you in the United States. It is possible to renew for 3 years or possible to extend if it's the same project, but there is no lifetime limit on how long you can stay on the O-1 visa. So definitely this can support a long-term outlook as well. By contrast, EB-1A and NIW are both green card categories, which means they're well suited for people who want to live and work in the United States permanently. And if you get a green card, there are some restrictions on how long you can stay outside the United States at a given time. So if you anticipate that you'll be spending long stretches of time in your home country, for example, the O-1 may be a better option because the green card has such restrictions. The other question to ask is, do you have a U.S. employer or agent, or do you want to self-petition? O-1 visas do require either a U.S. employer or a U.S. agent to file the petition. It is possible for an entrepreneur to establish a U.S. business entity and then have that U.S. entity be the petitioner to drive forward an O-1 petition. So that is possible. But in that case, you do need to show if there is actual work opportunity for that U.S. petitioner that you use. It can't just be a paper company. So there needs to be a bona fide job opportunity, but it is definitely possible for entrepreneurs to use their own business to sponsor their O-1. By contrast, EB-1A and NIW, they both allow self-petitioning, which means the foreign national beneficiary themselves can be the one who drives forward the petition. There is no need for a U.S. job offer. There is no need for a U.S. agent. So that is definitely a difference. For family considerations, very quickly, for O-1 visas, Katie already mentioned this in the previous slides, but spouses do not have work authorization when they're on O3 visas. They can come with you on an O3 visa and go to school, but work authorization is unfortunately not possible. By contrast, the EB-1A and NIW are both green cards, and if you get approved for a green card, your spouses and children under 21, dependent children can join your application and also qualify for green cards. So that can be a significant advantage for some people. All right, so briefly to go over some other strategic considerations when you're moving from a non-immigrant visa to a green card. So the first is to note qualifications. There is usually a higher standard to qualify for an EB-1A, even though the regulatory language is phrased very similarly. In practice, each type of evidence is looked at with a very much more stringent lens when the government is looking at an EB-1A petition as opposed to an O-1 petition. And so qualifying for an O-1A visa, and especially if you've qualified for an O-1B visa, which has an even lower standard, this does not mean that you automatically qualify for an EB-1A. You should definitely get a lawyer to look at your O-1 profile, and perhaps they can advise you of ways on how you can develop stronger evidence for each criteria to prepare for an eventual EB-1A petition. But you may not, be able to, use the exact same package to support just as a strong EB-1A case. So that may be an issue there. Timing, consider how much time is left on your current underlying visa. Some visas may be harder to extend or subject to more scrutiny once an I-140 or green card petition is filed. So if you're thinking of an EB-1A petition or an NIW petition, definitely talk to your lawyer to think about when you would submit the I-140, because that may impact some of your other visa considerations. Finally, if you have children who may also need the green card, there is a limit on how old they can be before they can benefit from the green card as a derivative beneficiary. So you may want to consider filing early enough to avoid issues with your children aging out at 21. So that can be another important timing consideration for EB-1A or NIW petitioners. All right, so the last question we will look at before ending, and I'm sorry that we're slightly over time, are extraordinary ability categories available for entrepreneurs? And the answer is a resounding yes. EB-1A and NIW are both green card categories that allow for self-petitions, meaning that both are possible options for entrepreneurs. Changes in the NIW standard under the matter of Denizar precedent case made NIW a much more friendlier category for entrepreneurs, given that in the past few years, NIW adjudication has become a lot more stringent than it was before. So definitely speak to us with your particular case. Not all entrepreneurs would be able to qualify for an NIW. You'll need to show a broader impact to the field rather than simply providing good services or product to your immediate clients. So definitely it has become a little bit more challenging. It is possible to apply for an O-1A visa as an entrepreneur, and I've went over this briefly, but you must have a separate corporate entity in the United States that would act as the petitioner. But it is, yes, possible for an entrepreneur to use that strategy. All right. So I don't think we have any questions that came in at this point. All right, so I guess we can close here. Thank you, Katie, for providing your excellent expertise. And thank you everyone for your participation today. And yeah, I look forward to seeing some of you at the next time.
Thank you, Jay.
Thank you.